I know that. I know. I don't think it's me. I think it's somebody else.
Yeah.
That's me. That's me. That's me. No, it doesn't.
Oh, there you go.
Next. Nothing. Then say back.
I wonder if there's a problem with the forward.
That works. Now let's see if this works. Left, right, left, right, left, right. So it should work.
Should work,
You try?
theoretically. Seems like it.
Cool.
Got the magic
Shit,
touch.
then.
Off the touch. All right.
No, I thought before some others struggled with this. It's fun.
Okay, welcome everybody to the last session of the day, but a very stimulating session I think this is going to be. So let me tell you, it's on data governance and cross-border data sharing. So these are a lot of questions with not firm answers yet. And the way we've structured this segment is to have two keynote speakers, but in between we have some of the PIs talking about some of the issues that have come up in their projects, and maybe not just the challenge end, but maybe they've discovered some solutions. So we were hoping that this would be helpful both in the practical and in the theoretical way. So our first speaker is Kiana Stanton, and she maintains a life in the air, I think, from her CV. So she's a senior researcher at the Institute of Biomedicine in Italy, but she's also a consultant to the WHO guiding principles on human genome data sharing. Plus, she's honorary research associate at University of KwaZulu-Natal and works with the Irish Biobank project. So there's a fair amount of traveling, I think, involved in her life, but we'd like to welcome her and glad she could make it to this event.
Hello, good afternoon, everyone. I'm delighted to be here to talk to you about a new initiative that's coming from Europe. And I'm sure many of you is wondering, why am I discussing a European initiative, particularly considering some of the conversation we've been having about whether or not we should be following other values. Now, there are a number of reasons why I've opted to offer some reflections on what is at the moment a draft regulation. And I'll outline some of these, offer some critiques on this process, but also tell you exactly what it means for you. I think when we are talking about data sharing, so far today and yesterday, we've talked a little bit about risk to the participant in the context of privacy. But we also need to be thinking about risk beyond just data protection. And perhaps when you guys are revising your policy on data sharing, may also begin to think what role the policy should have on risk to discrimination and stigmatization. What I think also in the data sharing space, we need to maybe not follow us risk-averse approach of us lawyers, but think about the risk of not sharing the data. What are the risks involved if we don't share the data? It's going to have an impact on diversity of data sets, downstream research outputs, but also what did you tell your research participants, for those of you who have collected the data, if you are not going to share data for admittedly often very valid reasons? Are you breaking your social contract or the social license that you have with your research participants? Now, this new draft regulation is going to change the narrative in data sharing if it becomes enforced in the European context, because it's actually going to create an obligation to share data for secondary purposes. So we're going to have to start shifting our thinking in the European space, but also in your context, if you want to access the data that's being held in Europe. And what are the obligations and what should we be thinking about as we shift that narrative to an obligation to share data for certain problems? But there are an awful lot of problems with it at the moment. One of those is this narrow focus of risk as being only to data protection. It is also only considering the right to privacy in the context of the individual and not all of the other privacy concerns that may flow from the use of data, such as genetic data. It is also going to introduce obligations for the sharing of anonymous data. Currently, our focus is on whether or not it's personal or anonymous data in the European definitions and landscape. And many of you be very aware that anonymization it's not that clear cut what sort of data sets, but it's going to introduce a legal framework for the enabling access to anonymized data. But for you, it's also, if you want to get access to data that's being held in Europe, legislative changes is actually going to be needed in your particular context if you want to get access. So I'm joining a healthy group of people who've had problems. Okay, yeah. So within the European context, there's a huge amount of changes that's going on since with the GDPR. We had the implementation of the GDPR, which has been fragmented, difficult for many of you who have been aware of trying to get access to that data. We have the AI Act, we have the Data Governance Act, and now we have the European Health Data Space. And what is that reason for that change? One of them is this issue of risks in the context of AI, but I'm going to leave that to one side because the focus for the European Health Data Space is all about enabling access to data for innovation. Europe has realized that it's not a very competitive industry or environment in the context of clinical trials, for example, and getting access to that data. And it wants to change that. It wants to fix the problem that was brought about by the implementation of the GDPR in the context of research and change the narrative so that there is going to be much easier to enable access to data. So how they're going about this is this new draft regulation called the European Health Data Space. It has two major pillars. One is on the primary use of data. And what is that is all about is giving rights to patients and enabling them to move their data as they move through Europe. So someone like me, who's lived in 4 European countries, every time I go to a new European country, I have to start the whole process of, this is who I am, this is my health issues. It's going to hopefully change that. But I'm going to focus on the other pillar, which is about the secondary use of data. Now, what the European Health Data Space is trying to do is to provide an infrastructure and a legal framework to enable secondary use of data. So it's not about establishing a central EU database of health data, but providing a legal framework to enable access to data. And importantly, it's about personal and anonymous data. It is about both. So all of these rules and procedures I'm going to talk about apply equally to personal and non-personal data if it is passed. And this is what it's all about. In recital 36, I think it is, 38, it says what it wants to do is unleash the benefits of the secondary use of data. It wants to get the data out there for secondary purpose, for the benefit of the European population. And so what the European Health Data Space wants to do is that, subject to certain conditions being met, it wants to create an obligation. So there will be an obligation put on data holders to share electronic health data with data users for secondary purpose. So again, it's shifting the thinking. It's not about have you complied with all the rules. It is you have an obligation to share data with others if certain criteria have been met. So let us go through some of these definitions, because these definitions, if you are going to look for access, are going to be a little important for you. So one of those is, what is electronic health data? Electronic health data is a very, very wide meaning. It's got electronic health records, data, genetic data, data coming from biobanks, electronic health data from registries, data from clinical trials, all data which is very, very difficult to get access to at the moment. And also it's actually looking at data that's contained in wellness application. Most likely that category of data will be taken out before it's passed because of data quality issues. But you'll see here that the definition of what it wants to give access to for secondary purposes is very wide ranging. And also the secondary purposes are wide ranging. We're not just talking about research. We're talking about a wide category of data. We're talking about use for public health, personalized healthcare, testing and training of algorithms, as well as scientific research. So again, it is very wide of how you can actually go about getting access to that data. So we see already that our definition of electronic health data is very wide, and our definition of secondary purposes is very wide. And I'm just going to pause here and say why that is important, because when we think about secondary use of data, we are still in the research ethics framework, whereas a lot of this data would not have been collected in the research context, but can be used in the research context. Equally, data that has been collected in the research context may be used for other purposes that people would not have agreed to if they had known at the outset. After all, when I walk into my health clinic in Ireland or Italy, where I spend a lot of my time, I think I'm only giving it to the data to my doctor so that he will treat me, not that it's going to be used for all of these purposes. So now we have a new entities created. Those of you who are lawyers in the room and data protection experts, you're being used to hearing like data subject, data controller, data processor. To make things really difficult, this is not the terms that are being used that much in the European Health Data Space. What it talks about is a data holder. And so all of you in this room will be, or most of you will be, a data holder. And if you're in Europe, you have an obligation to give a description of your data set to a new entity, which is called a Health Data Access Body. I'm going to come on and talk about that in a moment. So you have to give a description of your data set available to the Health Data Access Body. They'll make a decision. And if they make a decision in favor of the applicant and issue a permit, you must make the data available. And you must make that available in 2 months. Now, I work in supporting a biobank in the north of Italy, and we have a very, very thorough and robust data access framework and data governance framework in place for the last 11 years. We first collected our data 11 years ago, and we're in the follow-up stage of our project. We have made it clear that we will make data available to researchers only for these particular purposes, and the decision will be made by our Data Access Committee. That is being removed and will be replaced by this. So that actually has a lot of concerns for me. While I like the idea and the ambition of the European Health Data Space, we do need to make data available. I really stand by what I said at the beginning, that we need to think about the risks of not making data available. But I have concern in my context, in our biobank, what impact that's going to have on our community when they find out that their data is going to be used for purposes other than what they have provided consent to. But that's a data holder. Then we have this new body called the Health Data Access Body, and they're responsible for making the data catalog available. They will also process the application. Like I said, it will no longer be at the localized point, but it will be on a national level. And what the draft regulation says is that a health data access body must be made available in every EU member state. Now, the advantage for anybody wanting to get to access, if say, for example, you wanted to get data from 10 institutes in 6 countries, you no longer have to go down the road of 10 institutes applications and trying to navigate their frameworks. You make an application to one health data access body. So that is really going to streamline the process and speed it up. So there is benefit to it, particularly because not only do you not have to make it for the individual institutions, you pick one health data access body and you go to them for the access for all 10 different applications that you would normally have had to make. So they're going to process the application in line with the criteria that's set out in the draft regulation, and they'll be responsible for compliance and penalties. So even though all this data has been collected at a time when people didn't know their data was going to fall under this, they're going to be responsible for compliance and penalties. They will also issue the data permit. So they will issue the data permit to the person or the entity who gets access. But also in the interest of transparency, at the end of each year, they have a responsibility to report on the applications that have been received and the type of data use that has been made available. And then finally, we have the data user. And their responsibility is once they get the data, they use the data in line with the permit only. So we've got the data holder, we've got the data user, and we've got the health data access body. Nowhere here is the data subject, as we would have said in a GDPR terms, or the natural person, as they talk about in the context of European health data space mentioned. And the reason for that is that they've decided we're going to replace if consent is a lawful basis for the processing of data in any country, we are replacing it with this structure. Now, the European Parliament has come back and said that's an issue, and they want, as part of this dynamic interface, an opt-out mechanism. So if someone wants to access my data, I'll be contacted and I will have a time limit to be decided on which to opt out. But that hasn't been agreed just thus yet. Now for you, third country transfers. So if anybody here in this room wants to get access to the data that has been described here, you can use this legal framework. Now, for personal data, you still need to comply with the GDPRs. So issues around genetic data and the fact that it is considered to be personal data in the context of GDPR will still apply. But this is a framework which is going to enable you to get access to this data. But what it's also now requiring, coming from a proposal from the European Parliament, which I think will come into force, is that you will only be able to get access to that data on the principle of reciprocity. And what it means by this principle of reciprocity is that there must be a complementary legal framework or legal process in place that gives us in Europe access to the data in the country that we are dealing with. So in the same way that GDPR has required many countries to enact similar legislation so they can get access to data, it is quite likely that this will apply. And in addition, remember, you need to do this for anonymous data too. In addition, they've also said for highly sensitive data, such as that which has been listed here, we may need to put in additional rules, even if it's anonymous data, because we know anonymization is an issue. So we may even see more rules and particular subcategories of data if you are going to get access to that. Now, the question is it going to enable access to the data? In one hand, it's going to provide a more streamlined process, which is going to make life an awful lot easier for those getting access to the data. But what the problem is, as I mentioned in the beginning, the European health data space is only focusing on data protection issues. It is not requiring access to be considered with all of these other issues. For example, the Data Access Committee, I say that we have to check for stigmatization and discrimination where there is, but there is no requirement here. For you, what benefit will this have, or what are the implications for you? Well, it means that you're actually only going to get access to any of this type of data or use this legal framework if you have a new law in place. So there are going to have to be legislative changes if this is passed. I should also note that the European Commission is rather ambitiously hoping that this will be passed next year. More importantly, though, it means that if by having this requirement of reciprocity, it is coming back to this issue of Europe continuing to set the agenda on the secondary use of data. We know that this distinction between personal and anonymized data isn't very clear-cut. And often it doesn't make a whole pile of sense that like we have personal data highly regulated, whereas for anonymous data, we do not. But if we are going to have rules that must extend beyond Europe, I think a conversation needs to be had beyond Europe on whether or not these are the correct rules and if we should be thinking about other rules in place. There's also the issue that if you want to get access, you're going to have to abide by the European terms contained within the European health data space. And also the terms that are going to come out from these extra regulations that they are going to require for these highly sensitive data. And it's also considering the trend that I do have concerns in this space that data protection has become a de facto research regulatory framework, even though it is not. But because of the compliance issues and also the issues around fines, the focus has been very much on data protection and not the other issues. This trend is likely going to continue with the European health and data space. And because of this, and just to conclude, the group at DSI Africa Law, we are writing a response to our concerns on this third country transfer. And if any of you, particularly considering your practical hands-on experience, would like to get involved, we would encourage you to drop me a message and get in touch. And I think I finished on time.
Thanks so much. I forgot to mention that we're going to have questions. So hold your questions at the end. We'll have a panel with all the speakers and they can have multiple addressing of these issues. So our next speaker is Donrick Feldar, and he's coming to us from the Faculty of Law at the University of KwaZulu-Natal. And he's a PI of one of the research projects that's focusing on the legal aspects of the use of data science in health innovation in Africa. And the title of his talk is The Wisdom of Claiming Ownership of Human Genetic Data.
Greetings, colleagues. So after Dr. Staunton's very inspirational talk about the European health data space, I will take you back to our continent, to Africa. So I've put a QR code there, in the spirit of reaching a broader audience with our research. I've published my talk here as a blog on Harvard Law School's Petrie Flom Center's blog. So if you want to access it, there's the QR code. The establishment of a single data market across African nations promises significant socio-economic advantages, facilitating unrestricted and fluid data transactions and data exchange. This concept has captured the attention of political leaders and has been prominently featured in the African Union's Digital Transformation Strategy for Africa, a crucial document, as well as the Data Policy Framework. To transform the vision of an African single data market into reality and to unlock its potential benefits for the continent's people, establishing regulatory alignment is crucial. This necessitates the integration of markets, the implementation of uniform online payment systems, the standardization of taxation duties, and, importantly for current purposes, cross-border trade facilitation. There are two critical legal dimensions of cross-border trade facilitation. Namely, data privacy and the data ownership. When it comes to data privacy, there are evident opportunities for legal harmonization. However, The scenario is markedly different in the realm of data ownership, where a fundamental conceptual clarity is noticeably absent. This lack of a solid conceptual foundation poses a significant obstacle, and until it's resolved, the aspiration of an African single data market risks remaining an unrealized ideal. The journey towards this ambitious goal necessitates not just policy alignment, but also a deep and shared understanding of the foundational legal principles that underpin data ownership and privacy across the continent. In the realm of data privacy, the African Union Convention for Cybersecurity and Data Protection, colloquially referred to as the Malabo Convention, stands poised to play a transformative role. Consider the following harmonization approach. Every African country should legislate to automatically deem any other African country that ratifies the Malabo Convention as providing adequate data protection and govern personal data flows to such a country in the same way as domestic transfers of personal data. Consequently, personal data transfers between African countries that adopt this policy would be as seamless as domestic data transfers, effectively eliminating the need for additional legal hurdles in cross-border data transactions. This would create a streamlined system for ensuring consistent data protection standards across the continent. Nigeria, taking the lead, has already adopted an implementation framework in 2020 that provides for unrestricted cross-border data transfer among African nations, partly to the Malabo Convention. The potential for an even more robust data protection regime emerges when one considers the synergies between the Malabo Convention and the updated Convention on the Protection of Individuals with regard to automatic processing of personal data, known succinctly as Convention 108+. This convention boasts a potential global reach and is often seen as the international gold standard for protecting individual privacy rights. Remarkably, 6 African countries have already applied to accede to Convention 108+. In light of these considerations, an innovative proposition emerges. African nations might find it beneficial to adopt a dual ratification approach, embracing both the Malabo Convention and Convention 108+ as prerequisites for facilitating cross-border personal data transactions, devoid of legal impediments. This approach, as advocated by scholars such as Townsend, holds the promise of harmonizing data protection standards across the continent while simultaneously aligning African nations with global best practice. The prospects for similarly harmonizing standards across Africa with respect to data ownership rest on weaker footing. One sign of hope is the digital transformation strategy for Africa that calls for policy development towards ensuring data ownership, but it does not provide any further detail. The data policy framework released in 2022 handles data ownership in a profoundly confusing way. It calls for legal clarity and certainty on data ownership, but a few pages later, it dismisses ownership of raw data. It proceeds to conflate data ownership with intellectual property and then presents a superficial discussion and incorrect interpretation of a South African court ruling. Apart from getting the law wrong, at a practical level, it shows a puzzling lack of appreciation of the importance of ownership as a basis for data sharing and for commercial transactions in data. The AU's blunder stands in stark contrast with China's policy on data commercialization, which was released in the same year, 2022. China's policy realizes the importance of providing conceptual clarity regarding legal rights in data and sets out a sophisticated model of modular rights in data based on the practical reality of the various role players involved in today's cloud-based digital economy. Among others, data processors have proprietary rights modules in data, which may, in the case of personal data, be qualified by the privacy rights module of data subjects. In terms of the basic recognition of both privacy and proprietary rights in personal data, and the encumbrance of proprietary rights by privacy rights, China's policy is, interestingly enough, very similar to the position in South African law as analyzed by my research group. And there I've put the relevant article on the slide. However, there is no common African position. Also, in South African law, newly generated data would be res nullius, meaning it is not owned by anybody. And it means that a proactive step by the data generator is required to acquire the data. My research group has suggested that research institutions should proactively claim ownership of the data that they generate to ensure that they have the legal means to effectively protect that personal information. However, it would be far easier, and I suggest better, if there can be a clear universal legal principle established in Africa that data generators, such as universities, automatically own the data instances that they create. That will really empower them to properly comply with all the data protection legislation. I know that you can't wait to read that article, so there's a QR code that you can quickly scan. And now to move towards some solutions. The African Continental Free Trade Agreement is a landmark trade agreement signed under the auspices of the African Union. The primary objective of the free trade agreement is to create a single continental market for goods and services with free movement of people and investments. This will pave the way for a continent-wide customs union. The free trade agreement is expected to be one of the world's largest free trade areas in terms of the number of countries, covering a market of more than 1.2 billion people and a combined GDP of over $3 trillion. The free trade agreement in its current form does not directly address data as a digital good. However, there is ongoing dialogue and planning around the introduction of a protocol on digital trade. This protocol, that will be under the umbrella of the free trade agreement, is expected to encapsulate various facets of digital trade, from digital goods and services to digital trade facilitation, and importantly, the flow of data across borders. I suggest that its ambit should not be limited to just financial services and cloud services, but it should also include pivotal sectors such as data analytics and health research. The introduction of this protocol on digital trade could be a game changer in streamlining Africa's data governance and in paving the way for an African single data market. Yet, its realization depends on successfully addressing the core legal concept of data ownership. It is imperative that the protocol provides a legal model for proprietary rights in data, discerning their acquisition, their stratification, and interplay, especially when data contains personal information that gives rise to privacy rights of data subjects. Drawing from the insights of China's policy, which is clearly now leading the way, this legal certainty is essential, not only for the growth of the African digital economy, but also for fostering health research collaboration within our continent. Thank you, and I look forward to your feedback.
Our next speaker will be Paul Escolar. Paul is also a lawyer and has a great depth of background in electronic law, including a big recent focus on all the requirements of the Protection of Personal Information Act in South Africa. Oh, and your title of your talk is pseudonymous data set considered to be de-identified data in the hands of a third party? A very interesting talk.
We have tests to try and see if we can say pseudonymous correctly in our group. I don't think I get it right all the time, and I know Professor Thalder thinks it's pseudonymous. I don't know if that's going to help you, but good luck with that. I'm going to try and give you an elevator pitch of why you should care about this. And if I'm lucky, I'll get done in about 2 minutes, and then you can continue working on whatever else you want if that's important to you. But I want to try and tell you about a recent matter that's come out of the European Union, ironically, me being a South African attorney, and why we would care. So at a fundamental level, and we've already dealt with this in some detail with some of the previous speakers, if you would like to share data, you can go ahead and share data on a de-identified or anonymous basis. There have been some comments about, is it truly anonymous or not? We're not going to go down that road, but assuming for the moment that you de-identify the data, you're free to use it in the way that you choose, legally speaking. The second is synthetic data, and I thought we had a very valuable presentation a day or two ago from a number of people on synthetic data and the value of it and the de-identification ability of synthetic data. It's a very useful tool in the hands of a researcher, absolutely should be considered. Third example of how to be able to share your data is pseudonymous data. And at a high level, hopefully most of you know of this already, but just in case you don't, you've got one data set. It's got personal identifiers in it. A unique reference is created to associate it with a secondary data set. The secondary data set doesn't have any personally identifiable information aside from the unique identifier that can connect the two data sets. So in order for there to be personal information, you need both data sets. If you've only got access to this data set, then you end up not being able to tell who the individual is. This is a common technique. It's been known for many, many years and has been seen as a kind of security technique rather than a de-identification technique. So it was a way to try and protect the participants to a data study rather than to stop it being personal information, because by definition, personal information is information you can't re-identify, and you've actually got a database designed precisely to re-identify it. Okay, so it was conventionally seen that pseudonymous data was considered to be personal data, okay, notwithstanding, but very useful to try and reduce the risk of a data subject. And then finally, you've got identified data or personal data. So at a high level, that's what we're talking about. I'm just trying to contextualize it because what I really care about today is pseudonymous data, and hopefully you will too. So we had a case that came out of the European Union that collectively knocked the socks off the data protection lawyers, and this was it. It was certainly my position and the position of most of the people that I spoke to as lawyers that pseudonymous data must by definition be personal data, because you've got two data sets and you know exactly how you're going to identify an individual. Use the other data set. It must be personal information. But in this particular case, Single Resolution Board, which is a regulator in the European Union, provided pseudonymous data set to an auditing firm called Deloitte, who you probably would know. And they argued that giving that data set to Deloitte made the data set in the hands of Deloitte anonymous data, not pseudonymous data, not personal data. And when you start digging down into the implications of that, it becomes a kind of wow moment. Because if it really is anonymous data in the hand of Deloitte, what does that actually mean? So let's quickly look at what they argued. The first is that there are two ways of looking at personal data. Either it's identified, it says Paul, it's obviously Paul's data. So it's identified, directly identified, or it says the person sitting in the seat over there, and you can work out that that was Paul. So it's indirectly identified. And the argument by SRB said Deloitte could neither identify it because there was no name, but they couldn't even work it out. They couldn't figure it out because they had no way of doing it. So for them, it was anonymous in the hands of Deloitte. And they said that the risk assessment that was required would be necessary to determine if there was a likelihood of it being re-identified, and that risk assessment was not done. We'll talk about that a little bit later. Now, the European Data Protection Supervisor said, you've got to be kidding. Everyone knows that pseudonymous data is always personal data, and we don't have to talk about it. It's settled law. And the data required doesn't need to be in the same hands for it to be considered to be personal information. Just let me expand on that a little. Deloitte didn't have the secondary database. The single resolution board did, okay? And the EDPS says, I don't care who's got the secondary database. If someone in the world has a secondary database, it must be personal information. That's how it works. So the Court of Justice of the European Union took a look at this, and they said, actually, we agree with single resolution board. In the hands of Deloitte, we're going to consider it to be anonymous data. That's when all of us started rereading that sentence. And they took a look at the test for identification, which is a little bit of an old test for them. This is not, and they said, in the hands of Deloitte, we've got to consider how much is it going to cost for Deloitte to do it? How much time is it going to take them to do it? What is the available technology at the time and the expected technological developments? And they also were wanting to ask, or did ask, did Deloitte agree to keep it anonymous, which they did. So let's just go back to that. So that was the big deal for us. And what it meant for researchers was, if you take a pseudonymous data set and you send it to a third party, and that third party legally agrees that it's not going to try and re-identify it, then it is, and they have no easy way of doing it. So there's a kind of test. Then in the hands of the third party, that is not personal information or personal data anymore. That's huge, because it means that as you create that pseudonymized data set, and as you send it from South Africa to Rwanda, it's not crossing any border, because the data set that's crossing the border is not personal information. And so what you're able to do is take the entire of the data protection laws and effectively throw them out of the window as far as the Rwandan recipient is concerned. But the South African data controller, what we call a responsible party, still has all the duties of a responsible party data controller, because they obviously do have personal data. They've got the secondary data set. Okay. So what it opens up as a possibility, aside from synthetic data, which we've already spoken about, and completely de-identified data, which, as we've mentioned, is lossy. In other words, you lose data as you de-identify it that way, is the potential for a pseudonymous data set to be transferred across a border and to have essentially no data protection requirements necessary in the circumstances. And that's a big deal. There are a couple of things that we need to focus on just so that you don't equate them and make some false assumptions. And the first one is the data set, the pseudonymous data set, wasn't released into the wild. It wasn't sent to the public at large. What they were determining is whether Deloitte was able to re-identify it, not whether the world could re-identify it. And that's a critical distinction. So when you as a research institute give it to a third party, you're not saying release it to the public at large. You're sending it to a specific organization who says to you, I will receive it and secure it, and I won't try and re-identify it, which is important. And the second thing that was really important that came out of the judgment, which we thought was quite a wild idea, was that they only needed to consider the legal ways that Deloitte could use to re-identify rather than the illegal ways to re-identify. Now that's quite a wild concept for me, because we hear about data breaches all the time. And from my perspective, considering the illegal ways of being able to take a pseudonymous data set and re-identify it by hacking or whatever the case may be, I think that's a relevant question. The last question, which was really also a big deal for me, is that the court said the person who was alleging that the data was personal information was the European Data Protection Supervisor. And so the onus was on them to do the risk assessment and prove that it really was personal information. The onus was not on the Single Resolution Board. Now, I would have expected it to be on the Single Resolution Board as the data controller, and that was a surprise. So we ended up with an appeal, as you might expect. And the appeal said, at a high level, we think the court got it wrong. And we think it got it wrong in 3 ways. The first is, I can read it there. The first is that they required the European Data Protection Regulator to determine whether or not it was personal data or not. Now, the EDPS said, no, it actually has to be the Single Resolution Board that does that risk assessment. It shouldn't be us. Then the second thing is, they said, as far as we're concerned, pseudonymized data is always personal data. That's it. There's no discussion, and it doesn't matter who you ever give it to. Okay, we think we were still right when we did it in the first place. And then the last is that the onus of transferring it onto the onto the EDPS instead of onto the Single Resolution Board was a mistake as well. So that happened on the 5th of July. We've, Professor Tholdar and myself and a number of other authors have taken a look and extrapolated that concept to the South African situation. And we think that there's a relatively good argument that the South African Protection of Personal Information Act would follow the same logic that was followed in this particular case of Single Resolution Board. And as African researchers I mean, we've only looked at South Africa, we are arguing that the same logic would apply to a pseudonymized data set sent out of South Africa to a specific recipient that is contractually bound not to re-identify. And that, we think, is a bit of a game changer in terms of personal information law. That's it. Sorry.
So our next talk is by Dr. Bernard Ibuki. He's coming from Nigeria. He's the country director for the camera project at the research for research at the International Foundation Against Infectious Disease. And the title of his talk is Data Sharing and Data Policy Challenges and the Context in LMICs.
Good afternoon, everyone. So I want to first start by, I say it's a good thing to have had the first 2 talks, the talk by Dr. Stanton and also by Don Rich, giving the perspectives from European space and what that might mean for Africa. And Dr. Don Rich's talk on data ownership. So I want to speak a little bit more granular. I want to come home to within country perspectives. And for that, I'll be giving the perspective from the CAMRA project, which is one of the DSI research hubs. So the CAMRA project, titled Combating Antimicrobial Resistance in Africa using data science, it's a project that aims to evaluate antimicrobial resistance across 2 countries, in Nigeria and Rwanda. And those are the multiple PIs, Stephen Obaro, Christian Happy, and Derek Fouts. I think Stephen Obaro is here with us today. Yeah, so the project, I'll just give an overview, quick overview of the CAMRA project, and I'll go on to talk a little bit about some of our experiences with accessing data and challenges with sharing data as it concerns the project. So the project involves, there are two broad parts of the project. The project 1, which is looking at the clinical and molecular epidemiology of antimicrobial resistance in invasive bacteria from children. This is going on in Nigeria and Rwanda. And so for project 1, there are 2 specific aims. The first is to analyze phenotypic and genotypic profiles of archived enterobacterials from children in Nigeria and Rwanda. And to do this, we'll be determining their pathogen identity, identification, and the antimicrobial susceptibility of the enterobacterials using the automated platform, the Vitek2 testing platform. And then we'll also be performing whole genome sequencing using the Illumina platform to unravel unknown and novel mutations that may confer resistance. And then for specific aim 2, we'll be looking to characterize. So for specific aim 1, we're going to be working with archived isolates. And for specific aim 2, we'll be working with isolates that will be generated prospectively. So essentially for aim 2, we'll be looking to enroll children who are admitted to hospital. And we want to determine the distribution and the trends of resistant gram-negative bacteria in those children. We'll also be looking to correlate the specific multi-drug resistant organisms that we identify in those children with their clinical outcomes and the clinical course. And then lastly, we'll be looking to determine household reservoirs of multi-drug resistant infections. So, yeah, so for specific aim 2, I think I've gone through this already. I'll skip this slide. So for the project 2, the project 2 is a more is focused on the genomics of AMR and looking to translate that into development of point of care diagnostics and for new antibiotic discovery. So I'll just focus on the hospital and environment components of this project, and that is the prospective and the retrospective components of the project. Now, for the prospective arm of the study, where we are looking to enroll children who are hospitalized at the project sites, I'll just take a little bit of your time to explain the concept because it has implications for this subject of data access and data sharing. So here we have children who are seen at the hospitals. So we have hospital 1, 2, health facility 1, 2, and 3, depending on which site we are enrolling from. And then the children will be assessed if they are eligible based on the study inclusion criteria. And then once they're eligible, consent will be obtained, and then the children are enrolled. Now, please take note that at these health facilities, the routine service is being deployed by the staff in those hospitals. These are not project staff. These are staff of the health facility. They are usually employed by the government. Now, the children have been enrolled, and then we'll go on to complete case report forms for the study. We'll want to collect clinical samples like blood, cerebrospinal fluid, or urine. And then for the visit to the homes of those children, we will want to collect samples from the household surfaces, the stool or rectal swab from the human contacts in those homes, and then swabs from the animals in the home. Now, all these samples will be processed to generate data such as the culture, where we'll get the identification of the bacteria, and then the AST data. Now, these data may be considered as routine in these hospitals where the work is going on. But for the environmental samples, that's not done routinely. So that's a bit more project specific. And then lastly, we'll go on to also, for the bacterial isolates, they will be subjected to whole genome sequencing. This is done not routine. Again, this is done on the research platform. So what about the retrospective parts of the study? For the retrospective arm of the study, we're working with isolates that we have generated in our previous research studies in different parts of Nigeria over several years. So for this, we're going to reanalyze those isolates using contemporary methods. We want to analyze and establish the identification for those bacterial isolates, and then the AST using the same platform we'll be using for the prospectively collected isolates samples. And then we'll also do the same to whole genome sequencing for those retrospectively collected isolates. So here I just want to try and illustrate the different types of data that we generate on the study, and hopefully bring home some of the key points that speak to data access and data sharing. So on the camera project, at the health facilities where we screen children, we will generate, there will be screening data. Now that screening data, usually we'll access that from the hospital records or from the patient files. Then those data, oftentimes they're generated by the hospital staff who are employed by the government, not by the research project. And then when we have extracted this data, we'll go on to domicile that data on the study CRFs, and then subsequently on the REDCap database for the camera project. So the same thing applies for clinical data, where we also have to access patient files and the hospital records. This is done by the hospital staff. We simply work together with them to access the data that is needed for the project, and then we extract and enter that into the database. And same thing all the way down. So for the household environmental data, that is done purely by the study team, the research study team. We do work closely with the local government or the district health authority to access data such as their vaccination rates and things like that. And then we domicile the data on the study database. So, and then the genome sequence data, that is completely handled by the study team. It's generated by the study team and is managed in the database by the study team. So with that background, I will now want to talk briefly on the challenges and opportunities for consideration on how we can improve data sharing. So the first is regarding the difficulties with accessing the local data sources. Now, with the context that I've provided, I hope you're able to appreciate we have to work within the context of the routine health service to access quite a bit of the data that is needed. Now, most of the routine data in health facilities, I'll speak for Nigeria, is often incomplete and not sufficient, of sufficient quality for research. So we often have to supplement the structures in the routine health service to get the data that we need. And this applies both to health facilities that use paper records, as well as those that have electronic health record systems. So again, that's one challenge which we'll have to work with. Secondly, there are concerns regarding equity in the benefits that accrue from the research project. So oftentimes we get challenged by either the senior consultants in the hospitals or faculty in the university that are affiliated to those hospitals that they want to have clarity on what benefits that they will derive from our participation in their sites. So issues around authorship in the publications, issues around access to training opportunities, as well as what the research project is able to do to support and improve the infrastructure for collecting this data. Now, as simple as it might look, I mean, all of these might just look like they relate to data collection, but they have implication for data sharing because most of the stakeholders we engage with at the country level and at the state level, they are the ones that have to give permission and cooperate with us to actually share data that is needed. So, I mean, just something to us to keep at the back of our minds. So now, what about the policies and regulations in country regarding data protection and data sharing? So this actually varies widely across countries in Africa. In Nigeria, we only recently passed some policy document on data protection. And then there are also challenges with implementation, okay, low levels of implementation and low levels of awareness amongst in-country healthcare workers and stakeholders. So what opportunities are there for us to sort of address some of these concerns? So the first, and I think I would say more like the elephant in the room, is issues around equity in research outputs. Clearly, some effort is already ongoing on this, but there's still a lot more that needs to be done. There's also the need to strengthen understanding of our collaborators in country, understanding in research, understanding on ethical principles that underpin data sharing. And then there are issues around data ownership. I think this is something that will be really helpful to address this early on in the process rather than wait till much later. And oftentimes we see that assumptions are made. Okay, we make assumptions and think that it's clear who owns what and who should give permission for use of what. So I think these are things that need to be addressed early on. And then lastly, there's also a need to support. We can't run away from this. What is needed to generate the data in the first place. So I think I'll just stop there for now and thank the members of the camera team, Professor Stephen Obaro, and to your extreme right is Professor Stephen Rulisa, who is the lead for the camera project here in Rwanda. Thank you very much.
So good afternoon. I hope everyone is still doing well. It is my pleasure to facilitate the second half of this session. I'm Sudha Srinivasan from the Division of AIDS at the NIH. And our first speaker for this part of the session is Dr. Dirk Brandt, who is an extraordinary senior lecturer in Stellenbosch at the School of Public Leadership. He's a lawyer as well, has multiple degrees, and is extremely well published on topics ranging from AI and the law, data protection, public governance, and international relations. The subject of his talk is data governance and international cooperation, developing a data ecosystem in Africa.
Thank you, Sudha, for the introduction. And thank you for the organizers for inviting me to speak here. I really appreciate that. The sessions that I attended really was quite informative, and unknowingly, many of the presentations so far contributed to the context which I want to sketch quickly. When we talk about building a health data ecosystem in Africa, I think the starting point is taking stock, knowing what our point of departure is, what do we have currently, and what are the gaps or the issues that warrant attention before we can go into creating building blocks for a health data ecosystem. Well, this event underscores the importance of international cooperation, which clearly aimed at strengthening health research and outcomes that could positively impact healthcare on the continent and also elsewhere. The diversity of research projects clearly here is very informative to know about them and how they each contribute to overall a bigger picture of improving healthcare. Another important part of the current context is, and quite a few of the presentations looked at that, how do we facilitate better access to and sharing of multiple data sources? When we talk about new technology, development of AI in particular, it needs a lot of data. It needs well-established, high-quality data sets to work with. Good health information systems are crucial in fighting health pandemics that we've seen during COVID, that we need that. And it was not obvious that it existed everywhere. We obviously need appropriate and adequate legal frameworks. We've heard references to some of those already today. And when we talk about technology, there's an increased use also within the context of health of using a diversity of apps, AI systems, continuously new systems being developed, and other related technologies. As part of the landscape in Africa, there are many data protection laws existing, but not in each country on the continent. Regulation of cross-border data flows are done almost on a bilateral basis. There's no uniform law for the continent like we have the GDPR in the European Union. Another important part of the legal landscape is the development of data transfer agreements, of material transfer agreements in the context of health that could guide the efficient and legally sound cross-border flow of data. Now, interestingly, some of the projects presented here already provide some food for thought in terms of contributing to what I would call some of the building blocks of a health data ecosystem. And I'm thinking particularly in one of the presentations earlier this morning about structuring data access, developing an ontology for data use, making sure that there's a standard terminology, categorization, in data storage, in data access being developed. Now, these are crucial developments that we need going forward in developing a health data ecosystem. In the end, all of these projects contribute to creation of new knowledge. We hopefully get some innovation included in that as well. But it's not all the elements are not there yet when we talk about building a health data ecosystem. There are quite a few gaps, quite a few things that we need to attend to. Clearly, there are different levels of institutional capacity all over the continent. Some places you might have outdated or inadequate health data systems. The previous speaker mentioned to some of the problems that they experience in their research project with capturing data. It's also not a given that there are pre-approval of health data sharing agreements in all of the countries on the continent. There's a lack of standardized data categories. And if we want to collaborate across different countries, not only in this consortium, but even wider than that, you need at least a degree of standardization that if you capture data in one country, you use the same ontology, you use the same categorization in that same context in another country. It's not easy, but that's the direction that one will have to go in enabling a health data landscape. There are many ethical concerns regarding data sharing, and I'm not going to go into detail about that. We've heard some of them. Sorry. When we talk about new technology, there are concerns about using AI. It's not obvious to everyone, consumers, that this technology is to their benefit, and bias is a big issue. Discrimination is a big issue. Transparency is a big issue. So we need to find answers to all of those. When we're developing a health data landscape for Africa, and obviously that's something we will have to do on the continent, we have to look at what's happening elsewhere in the world. We're not living on an island. We live in a globalized society, and it's relevant and important that we reflect on some of these international developments. And I want to start off by referring to two key documents produced by the OECD in the last few years. The first one was general on improving access to and sharing of data, so not health specific, but more data in general about data access and data sharing. First recommendation that they made was to say that the promotion of trustworthiness of the data ecosystem is important. So you need to build credibility of the institutions and the processes that can contribute to that trustworthiness. It's important to enhance transparency and data access regarding access and the data sharing agreements. So be informative, engage the community that you work with in enhancing this transparency. Third recommendation is to incentivize data access and sharing. And lastly, important to foster effective and responsible data access, sharing, and use across society. Now, some of the earlier presentation in this session talked about the secondary use of data and the importance of creating the appropriate framework and understanding that can happen effectively. Then the OECD produced a policy document last year on health data governance. And that one specifically refers to establishing of national health data governance frameworks, something which is very important when we talk about the continent developing a health data ecosystem. And as part of that recommendation, their focus was on what's happening in individual countries in establishing credible institutions, capacitating them, and also developing best practices that you can use in collaborating internationally with other partners. Second recommendation is to strengthen trans-border cooperation. Now, we all sit here working with different international projects, so international cooperation is crucial for us. I will skip that last part just for the sake of time. Refer to the third document, the World Health Organization's recent publication on policy and implementation regarding health data sharing. The principles they indicate equitable, ethical, efficient, and to follow fair principles. And the second key issue is develop a data management and sharing plan for each research project. Now, I think one can take guidance from that as well. Chiara made a very informative presentation about the European health data space, and I'm not going to go into detail about that. Point is, we need to know about that, we need to reflect on that and see how that impacts us in Africa. So let's look at data governance in Africa. The key policy document that provide a basis for our discussion is the AU Data Policy Framework adopted last year. And there are important principles of transparency, accountability, inclusivity, and equity. And it contains a number of recommendations for member states to develop a consolidated data environment, that's what the terminology that they use, and harmonized data governance systems. How do we do that? Can we talk about African health data space? I don't think so at this point in time. There are too many asymmetric situations and too many gaps to address. But how do we respond then to this AU data policy framework? Well, this document in particular also mentioned the incremental or progressive realization of that. And that means you will have to find innovative ways of developing that health data ecosystem. And I would offer two solutions. One is a regional health data space, and the second one is what I would call connected health data spaces. Could leverage other policy documents. We've heard earlier about the AU's Cybersecurity and Personal Data Protection Convention, the Continental Free Trade Agreement that was signed here in Kigali. Important is that the focus should be on the legal frameworks, institutional frameworks in the different countries that could contribute collaboratively on establishing a health data ecosystem. We need to strengthen the data infrastructure to support data-driven technologies such as AI. That is the direction the world is developing. It's important to collaborate to build institutional capacity, and some of these projects that we heard about this today and yesterday really focus on strengthening that institutional capacity as well. We need to strengthen the international data transfer arrangements that could contribute to this health data ecosystem. Cybersecurity and protection of personal data are key elements of that. And in the end, it's also about promoting trust in the health data system. Data subjects, consumers, users, and scientists, we all need to have trust in the system. So the two models I would suggest: the regional health data ecosystem, where neighboring countries, ECOWAS, SADC, or whatever grouping of regional countries come together and say, but we are ready. We want to develop this health data ecosystem for us in this region. I think this AU data policy framework allows for that. The second possibility is what I term connected health data ecosystems. Researchers and institutions in Kenya, in Rwanda, in South Africa, for example, argue that this is what we would like to do, to connect these countries in establishing a connected health data ecosystem. But there need to be criteria, and that needs to be developed. The key building blocks must be there: harmonized legal frameworks for data protection, institutional cooperation must be established properly, standardized data categories must be there, and interoperability of health data, while importantly protecting privacy and human rights. I want to conclude with this reference to the World Health Organization, who emphasize the need for creation of health data ecosystems to support innovation and health and knowledge creation. And in the end, it's about how do we benefit society by doing these things. So I thank you.
Thank you so much for setting the stage. Next up, we have Dr. Christy Michelle McKinney, who's an epidemiologist. She's based at the School of Medicine at the University of Washington in Seattle. She's an associate professor of craniofacial medicine, and her focus is in translational research and generating new knowledge and tools that directly translate into improved care and improved oral and craniofacial health for young children globally.
Thank you for sticking with us. I know it's a hard time of day. We're all post-lunch and it's getting to the end of the day. So I appreciate you being here to listen to concerns. So actually this presentation was really brought about by a question. I'm part of a training program within DSI Africa. And I'm just going to give you a little bit of context about the data we're using and some ethical and legal questions that we have around that data. And I think there are plenty of lawyers who might be able to, and ethicists in the room who probably have some perspectives on this that we would welcome. All right. So we have a broad partnership in our training program across many different institutions and different disciplines that you can see here. The framework for our training program is, I guess, well, to step back a minute, we're here to learn more than anything else. Just to give you a framework for our training program, we have several, I'm not sure this is the same presentation that I thought I uploaded, so I'm just a little disoriented here, so stick with me. Let me just make sure. There we go. Okay. So I'll start off with our training program. Our training program focuses on these different data science disciplines within 3 primary health contexts, and those are malaria vaccine development, injury control and prevention, and then the third one is in orofacial clefts. And so that's what I'm going to spend a good amount of time talking about. And in particular, I'm going to talk about data that we're receiving and working with SmileTrain, who's one of our key partners in this training program. So as I mentioned, we're here to learn, and we have a bunch of different layers of ethical concerns when we think about the data set that we're using for our trainees that are highly identifiable. And this really revolves around SmileTrain. So I'll tell you a little bit about SmileTrain. SmileTrain is a nonprofit, and they are based in New York City in the United States. They, for the last 20 plus years, have supported surgeons in local contexts, so in countries in Africa, South America, and Asia, to do surgical interventions on children who are born with a condition called orofacial clefts, and that's a gap in the lip of the mouth or the roof of the mouth. And this particular type of congenital anomaly has huge implications for the survival and well-being of these kids. They're often shunned, and there's a lot of challenges with getting them care. And so SmileTrain has a database that they have collected through their programmatic work. So a surgeon will join and a hospital will join SmileTrain. And when they join SmileTrain, they agree to provide information on the patients that they do surgical interventions on. So they provide a fair amount of pre-surgical information about the child. And this includes a number of different types of data. And then after surgery, they collect additional information, and then they provide the payment to the surgeons for the work that they've done. So that's, the database is very programmatically oriented. It is not, wasn't designed for research. It wasn't designed for healthcare. It was really designed to ensure that these children are getting the surgeries that they need locally. And just a couple of other points here is that they have data from 90 different countries, I think over 1,000 different hospitals. And at this point, I think they're at about 1.5 million surgeries. So as I mentioned, there's no consent. The patients do agree to be part of the SmileTrain program, which means that their surgeries are paid for. So there's no out of pocket for the patients to receive the surgery. And there's not really ever been an explicit agreement for this data to be used for research purposes. It has. It's been used to learn from, and papers have been published using this data source. So I think that the actual presentation that I had planned on isn't uploaded. So I'm just going to talk a little bit more about some of the ethical challenges that we see with this. So one of them is just around the fact that the data wasn't collected for research, it was collected for programmatic purposes. One of them is around the images. So we have very, the required data that is contributed includes facial images, multiple facial images before and after the surgery. There's a speech data. So we have audio data on patients that we're using. And because SmileTrain is not at an academic center, they are a program, we can get ethical clearance from our institutions, but I guess so that's one sort of consideration that is sort of a very traditional model, but we haven't worked with a partner like this before. So we're not sure like if that's sufficient. And then I guess the other sort of question is the hospitals and the providers themselves who put the data in, who actually did the surgeries, are part of this picture as well. And so what considerations do we have kind of at the caregiver level, the patient level, the provider level, the hospital level, given that the various different data types? And I know that it'll depend on the particular question that a student is asking. So if they are asking an image related question, there could be potentially different issues than if it's a de-identified or anonymized data set with clinical data only. So thank you for your flexibility, not being exactly what I expected, but that's sort of the context that we're wondering about and posing as a question in terms of what sort of ethical concerns we should have or considerations or things that we should do differently that we may not have normally planned on.
Okay, last but not least, it's my pleasure to introduce Dr. Prof. Sagi. I hope I'm pronouncing that correctly, who wears multiple hats. He's based at the University of Yaoundé, and he lectures in biostatistics and health informatics. He's associated with the Cameroon National Institute of Statistics, as well as the Ministry of Public Health. His research interests include topics in data analysis and data science. He's also one of the MPIs in DSI Africa, and the title of his talk is Harnessing Data Science to Promote Equity in Injury and Surgery for Africa, DSIGN.
Good evening to all. So I want to present an experience on how to make an advocacy for strengthening data health governance. This is an experience from Cameroon. So I am with the data science in data science, which is where we have two projects. Our main goal is to a long term is to improve health equity in Africa, especially in the domain of trauma. And we have two projects. Project one is on equity surveillance. Project two is on trauma trauma predicting outcome. And we have also some future project like pilot project or sit-down project. And we are collaborating with the University of Berkeley, University of California, and UB, University of Boya, MS Cameroon, and the University of Cape Town. We have a Denmark who is coordinating our data management. So, but here we want just, as I said earlier, to make an experience of how to make advocacy for data. For example, in the morning, we will try to see how to design a policy for data sharing. But once that policy is designed, how can we advocate that policy so that this can be adopted? Yes, we already know that technology is growing rapidly, and then we have very huge amount of data. And with this amount of data, we know that we need some strategy to how to make data governance in this area. And we can also we need legislation. And there is an organization called Transform Health, which is based in Switzerland, has developed some principles for data governance, and they made consultation meeting in many countries. And the idea was to test this in various countries so as to see whether those principles can be adopted by the WHO. Though Cameroon was selected as one of those pilot countries where those principles was tested. And here in the background in Cameroon, we don't have a specific law in data governance, but we have a statistical law in which we can have where we guarantee the confidentiality and data protection, data privacy, data integrity. And we also have a health law that come out in last year in medical research, where there you also have some data policy. And then our objective was then to present those principles of health data governance to stakeholders in Cameroon and explain them why it is important, those principles. And then we have taken that opportunity to assess the perception on this health data governance. And the methodology was that we organize a roundtable discussion, and we also make a survey to have an idea of their perception. The roundtable took place in May 10 to 11 in 2020 at the Hotel des Députés in Yaoundé. And this work was in partnership with Pan-African Association of Medical Informatics, with Transform Health, with Cameroon Society for Medical Informatics, and also Cameroon Society for Statistical, Cameroon Statistical Society. That roundtable was co-chaired with the representative of the Ministry of Health and also the Ministry for ICT in Cameroon. And the attendants were the government institution, were international organization, were private sector, civil society, researcher, academic, and also donors. We present the overview of those principles, and these principles were 8 in number and divided into 2 groups. The one was to protect people, second one to promote health value, and the last one to prioritize equity in health. The first one, protecting people. The most important there is that any health governance should consider that, and the people should be protected at individual and also at the community level. That's the essential of that one. And the second one is how to build trust in the data. This requires that data should be well preserved for integrity or transparency in the process, in the whole process or life cycle. That is from the production of the data to interpretation. We should take into account in the overall cycle of the data. The other one is data security. So data should be well stored, because if it are well stored, then we can be sure that integrity should be guaranteed. Now, talking about the high value, data governance should also be in such a way that we can expand and can clearly explain how people can get more value for the data, and that this also be shared in equitable way. And another one was in terms of operability of data. So data should be the structure to collect data should be made in such a way that many various data collection tool that data can be shared on various platforms, including the type of data. There can also be some innovation while collecting data. Should not be always the same thing, but there should be a possibility to innovate when data are collected. And the last one was equity in data. So in that principle, for example, if you collect data in a community, people from that community could to also get access to that data. And usually we see that it's not always true. When you collect data in a community, we are not guaranteed, there's no guarantee that when people living in that community try to get data, they will have an advantage of getting access to the data. That's why that we call some kind of equity in the benefit of data, because they should also benefit from this data. And also we have also talking about the ownership of the data, that this implies the individual have the right to know and control their own data. So you can also ask, if somebody asks you about your data, you are free to tell him what is he going to do with data. Can you get access easy to data? What are your right? That was another principle. And after this, we share the finding of this to various stakeholders at the national level. That's the link that we advocate all the information that we're getting from this round table. Also, we also share the finding with the social media in Cameroon. You also have the link here. And when we measure also the perception of stockholder, we have 16 of them, and majority were men. The age group represented were 25 and 30 years. And these are various institutions that were represented. You have NGO, that was the most, university institute, you have civil society, and then governmental institution. And the survey showed that nearly 60% of people strongly agree with the overall objective of all those principles. Strongly agree. And we also saw that if we take the principle 1, there were almost all of them agree or strongly agree to that principle. Why in the second one, in the principle 2, we have nearly 60% that agree according to that principle. And for objective 2, this was about 90% of people who also agree on various principles. The less was principle 5, where nearly 50% of people agree on that. Yeah. And another was the principle, the one on equity, and we see that 75% of people also agree with that principle. And we also have, when you put all the principles together, we see that principle 3, 1%, all people agree on that principle. And the last one I said earlier was principle 5. You have here a picture of all the stakeholders that attend that meeting. At the middle, you have the representative of Ministry of Health and ICT Ministry, and also all the stakeholders. And there are some people also here that attended that stakeholder meeting. We also have here a sequence of when we were presenting this to the audience. And here at the end of the roundtable, participants were getting certificate for their participation. And this was given for the representative of both Ministry of Health and Ministry of ICT. At the end of the day, the stakeholder recommend that government of Cameroon support during the World Health Assembly, that principle be adopted. And here you see that here we have the Minister of Health, the representative of the Minister of Health in Geneva, following our recommendation of the meeting, that Cameroon can support that to be adopted. That you will see here. So, as I said earlier, we recommend that the government should participate in that round table in Geneva on data governance on 2022, and then they support this. From there, thank you very much for your kind attention.
Thank you all. Let's have a round of applause for all our speakers. And I'd like to invite the speakers up to the podium for a panel discussion. And this is an opportunity for the audience to ask all those burning questions you've been holding during the whole session.
Hello, I'm Bonnie Joubert from NIEHS, part of NIH. So I have a question for Paul and maybe Donrick, but it's more Paul's presentation. So I found the pseudonymous, wow, I've never said that out loud before. So synonymous, I'm not going to try again. That other category of data to be interesting, and I've not heard of that existing in NIH. And so my question for you is, have you had conversations with NIH policy developers on the different ways you're proposing data could be categorized? Because if that doesn't exist at NIH ultimately wants to know, does this study involve human subjects, yes or no? Does it involve personal data or PII data, personally identifiable information data? And that determines the documents that need to be provided, ethical review approvals, IRB approvals, things like that. And it determines how we code things and what we require PIs and your business officials to do. So can you comment on that and your alignment of where you found things going with NIH policy when you have an NIH grant involved?
Well, I mean, sorry, I just had to find the button. The short answer to your question from my perspective, and I can't speak for Donrick, is that the answer is no. The pseudonymization concept is actually quite worldwide. So you'll find pseudonymization even as a principle in Australia's data protection law. It's of that level of importance. But you know, the EU's had it for multiple years now. It's been a thing for them for a long time. South Africa, for example, doesn't actually mention pseudonymization at all in its act, but it does in one of its codes of conduct. So that's an interesting sort of dynamic where we're starting to take a look at it. And the code of conduct I'm talking about is for research. So it's highly relevant because it's the same code of conduct that would bind a South African researcher from the Protection of Personal Information Act. So back to your question, which is there integration between us and the NIH on this concept? From my perspective, no, but the only thing I need to say about that is I'm relatively new to the NIH project. It's possible that Donrick has in fact done something about that before. Want to take one?
Our study of pseudonymized data is focused on legal compliance. And as Paul mentioned, the concept of pseudonymized data is known in quite a number of legal systems. And Ms. Edgecombe has recently written an article on terminology, specifically looking at which African states refer to pseudonymized data and how they define it. And it's actually striking how similar it is defined in the various African jurisdictions and also in Europe. So we're looking at it from a legal perspective, a perspective of legal compliance, and we didn't specifically try to align or try to match it with the NIH policy. If there's a specific objective to be served, then we can of course have a look at it. We would be keen to do so.
So thank you. Just a follow up. The specific example, maybe to chew on, and we can talk later, is in Paul's example with SRB and Deloitte. If SRB and Deloitte are two different, if they're not on the same grant, and Deloitte has de-identified data, that's, you know, it follows what you were proposing, I think, where you wouldn't have human subjects data involved, the regulations and implications of the NIH grant would be different. If SRB and Deloitte were on the same grant and one of them had access to identifiers, that changes everything. So that would be an example of where what you're proposing, it makes a difference at the grant level.
While you're looking for another person to ask a question, I think that's a useful clarification, because the one thing between SRB and Deloitte is that they were very different organizations, obviously. And in your specific example, you're looking at people that are effectively collaborating together. So the question becomes, and then the question which the court was asking in the first place there was, how possible would it be for Deloitte to re-identify? And if the answer to that was just to go to your fellow collaborator and get the other data set, then you're good to go. It is personal information because you know how you're going to do it. In Deloitte's case, not only were they a separate organization that was not, but they were specifically contractually prohibited from trying. Okay.
So if I can just partly respond to what Donrich said there. We've had the opportunity to engage with DSI Law on this. We had a meeting with them in Nairobi to discuss this issue. And I think our response, having had the opportunity to think through it very carefully, is that we separate the legal and the ethical issues. So what this does is it allows us to legally transfer data and to analyze the data, but it doesn't affect the ethical requirements at all. We're still subject to our internal IRB. Because of the consequences of misuse of the data. So if we were to take the data is pseudonymous in our hands, but if we were to put it on our website, then it's no longer, it becomes data that is personalized data. And so there's an ethical consequence, even if there isn't a legal consequence for that. So we didn't think of that in terms of the NIH policy, but my view is that it wouldn't affect the NIH policy. It would still be, from an NIH perspective, it would be personal data, but maybe you've had a chance to, we've thought about that, and that's been our response to that.
Thank you, Scott, for clarifying that. And I think also thank you for the opportunity to be with you for 2-3 days there in Kenya to really talk this thing through, because it was very valuable to apply legal theory to an actual practical use case, where we've decided that if data is pseudonymized, then it can, well, then it's not personal information in the hands of the recipient, provided that there are proper contractual safeguards put in place. And I think, as Paul also mentioned in his talk, there's a difference between sharing pseudonymized data set with a specific recipient and making the data known to the world, because clearly, so I think we've recently, we've authored 2 articles on this. The one specifically investigating or discussing single resolution board. The other one just asking the question about whether one can transfer pseudonymized data from a purely PR South African legal perspective, noting single resolution board, but not relying on it at all. So this latter article hasn't been approved for publication, and it's the proof stage. And the conclusion is similar for different reasons, but the similar conclusion reached by the European General Court, namely that one can do it, and that pseudonymized data set can then be non-personal data in the hands of the recipient. So the test remains objective. So it's not whether the recipients subjectively think that they can identify it or not. It's still an objective test of a reasonable method to identify. But the test is just context specific instead of context agnostic. So the difference is in the hands of the recipient versus anybody in the world. I've now elaborated a little bit on this topic. Would you like me to address anything else specifically?
Well, I just wanted to ask Paul a question about it, because you mentioned the appeal at the end. I want to be clear because it was slightly ambiguous. That's an appeal you were giving the arguments of the appeal. You weren't saying the finding of the appeal court. Correct.
Yeah, unfortunately, the appeal hasn't happened yet.
Yes, okay.
So I can't guess which way it's going to go, and we're having a bet over here as to which way it's going to end up.
Yes.
We can place bets.
Thank you. So I just want to, my name is Stephen Obaro. I am a pediatric infectious disease physician. And I think I am going to just try and address something that I feel is very practical, but we don't seem to have paid much attention to in the course of this meeting. Data sharing is great, but I think we're not paying enough attention to the fact that you can't share what you haven't got. We're not paying much attention to data generation, particularly here in the continent of Africa. And I'm saying this particularly from the aspect of health data. Now, I happen to be working on a subject which a lot of us probably don't appreciate, the enormity of antimicrobial resistance and the number of deaths that is attributable to antimicrobial resistance, not just in Africa, but even in Europe and the United States. Now, the main difference is the fact that in the United States and Europe, I wouldn't have to bother that much if I were to be ill with a bloodstream bacterial infection. I walk into a hospital, all the tests will get done without much effort. But here on the continent of Africa, where according to a recent review published in the Lancet journal, Sub-Saharan Africa actually has the highest burden of antimicrobial resistance. Now, to define that burden carefully, what we need to do is to find bacterial isolates from children or adults who are ill with maybe meningitis, urinary tract infection, or pneumonia. To make the diagnosis, we require laboratory consumables, expertise in the lab, which are often not readily available. Now, it's okay to have a research grant to support procurement of the consumables to get the bacterial isolate, which needs to be tested. Now, when the government that is supposed to be the custodian of the data does not provide the means for actually generating that isolate, if a patient has to pay out of pocket for the diagnostic workup that leads to the generation of that isolate, who owns that data? An argument can be made that because the patient has paid out of pocket, if the government wants to have access to that data, perhaps the government should be buying the data from the patient. Now, I feel very strongly that if we are going to move forward with this whole concept of global data sharing, particularly in the health sector, we need to pay more attention to data generation. Another classical example is the fact that several hospitals on this continent do not have electronic health record system. Those that do, the quality is very poor. You can't extract meaningful data from there. And then if for whatever reason you come along, you want to advocate for data sharing, there has to be significant investment that goes into generating quality data. Now, before I round up, I also want to mention that the example that I gave with patients having to pay out of pocket for generating, say, bacterial isolate that will contribute data for understanding of antimicrobial resistance, and indeed data for manufacturing new antimicrobials. At the end of the day, when those antimicrobials are manufactured, they are very expensive, and the chances of them being readily available here on the continent of Africa is very slim. The unit costs of doing a blood culture, for instance, in a child who comes in with severe meningitis, bloodstream infection, the unit cost of doing that work up here on the continent of Africa, when it's available, is more expensive than doing it in Europe. So where is the equity?
Anyone on the panel willing to respond?
I think when we are beginning to, well, not beginning, when we are thinking about a globalized data governance framework, we actually absolutely have to have considerations of equity. And when people talk about benefit sharing, it is whether or not those who's giving the data will actually get access to that data. I want to actually circle back to a point that we've been talking about ownership of data a lot. And I'm wondering if that is necessarily the correct concept to be using in this sphere. Somewhat disagree with other panelists, but I'm not sure if we really should be talking about ownership and if it is beneficial to the conversation. And I'm wondering whether or not we should not consider other words, particularly when we're talking about the data holders, such as data custodian, data steward. So there is a responsibility in how they use the data and share the data, but they don't necessarily own data. Conversations we've had in a different context with research participants, they really don't like that concept of data ownership to apply to what they perceive to be their data, and will always be they perceive to be the data. Whether or not that's true or not, I think we need to be cognizant of that is a concern out there, and perhaps other concepts should be used instead of ownership.
Thank you. I wanted to actually follow that up with a question or a comment. When should people be thinking about data ownership, sharing, confidentiality, privacy? You know, when you're designing an experiment or a clinical research trial, you know, you have your informed consent, and there is some language about sharing data, and, you know, what about sharing secondary data or tertiary, or there's so many levels of data sharing in this space. So it's something, I guess, for the audience and the panel, like, should the data folks be more engaged right at the beginning in the study design, when you're trying to get informed consent, when you're trying to get your study going? And I thought maybe if anyone had comments or thoughts on that.
Right at the beginning, you know, in the data protection, particularly in the GDPR context, we talk about privacy by design, which is you think about how you're going to protect personal information or personal data right at the beginning of when you start to collect data. By having considerations of privacy, issues of what you want to potentially do with the data at the beginning, you can embed all of that in your consent and future-proof it as much as possible to enable you to share data. It does require more of a consideration of who am I going to share with, for what purpose, and issues talking about secondary use. Also, I think an issue that we've come across is when we have conversations around industry. Industry does have a very important role to play in this place. People do have concerns around that, but the reality is we need to engage with industry and share it with industry. Having that conversation with participants at the outset of you collecting their data, and like, you know, provide them guarantees on why you think that they should share their data and so forth, for all of that will allow you to future-proof your consent as much as possible. So thinking about all of these at the time of data management plan as well ensures that you have a more robust data governance framework in place. But it does require you to think more about potential downstream uses.
Thank you.
Yeah, thank you very much. I want to follow up with him with the question and the concern. It's really, as he mentioned, there's a big challenge with data, and the data that are available, of course, we are not so sure if they have quality. And I totally agree with him that we have to look into other added investment of having quality data as we look forward to share the data and have the fruitful results that we're expecting. But again, I think the process that has started for looking at ways of sharing data, laws and guidelines and harmonized regulations should continue. As we have data, we need them. And even if they are there before we have quality data, then we work to get the quality data, but when we are sure we have good guidance on how to share the data. So to me, we can work on it parallel, looking at having quality data, but also looking at how can we have good guidance on data sharing. So both processes are required, are needed, but the challenge also for data sharing should be looked into. And for sure, I thank the presenters, especially who looked at the different, who presented at different ways of looking at policies and guidelines and laws for data sharing. This is really a high need. Thank you.
Thank you. Any comments from the panel?
I would actually just turn the question back to you all and invite you to give the feedback that Paul and Nishinganwe and Donrick are looking for when they're thinking of their data sharing policy. What exactly do you need guidance in the concept of data sharing, and give that feedback directly to them to enable them to respond to your need most accurately. They've said that they need to hear from you. So use this opportunity of the remaining time we have to feedback directly on what exactly your needs in the context of data sharing are, and then they can figure out what's realistic in the context of their mandate.
Thank you. My question is for Dr. McKinney regarding the Smile Train data that is essentially what you would call legacy data. And like you said, it wasn't really consented, but you're allowed to use it. How would you share that sort of data? How would you even de-identify it, given that it's facial images? Once your work with it is done, and in the future, does Smile Train plan to share this data? And if they do, what are their plans for sort of anonymizing that sort of data?
Yeah, I don't think we have the answer to that. Maybe I should talk with Donrick and colleagues about how to manage that. I think that's kind of what we're wrestling with a little bit. We want to make sure before we get into things like at the start that we're doing it in an appropriate manner.
I wanted to give that a bit of a shot. It occurred to me that perhaps the model you're looking for is federated data analysis or data visiting. So essentially, you've got highly personal data that is difficult to make less highly personal data. And so what you're looking to do, and unfortunately it takes some effort, is to create an interface whereby you never have to take your personal data out of the country or necessarily even out of your servers, but allow for a researcher to be able to run an algorithm against what you've got. And that's where the development comes in. If I were to just go out on a limb, I would say you might be able to sell that kind of data to a pharmaceutical company as de-identified data. So they would run an algorithm, they would never get any personal information, but that access to what, in my view, is quite a big sample size could be very valuable to them. You could then, as a nonprofit, take the money in, and it would allow you to be more sustainable as an organization, fix more smiles, as it were. And that might be a helpful way. There's a whole lot that you need to consider as you run down that road. And I think Professor Nikki Mulder might also be able to help you in terms of how to practically do that. That's the one thing, if that's okay. I wanted to ask one quick question for Chiara Staunton, because it was in the interest of mine. There's a new EU Act regulation called the Data Act, and what it's intended to do is it looks at the Internet of Things, and what and so, for example, if I've got a mechanical arm or a prosthetic arm and in some way it's internet connected, then the data is referred up, and that kind of data is dealt with by the Data Act. That's the one piece of legislation. That legislation, everyone in the EU was really worried that that kind of Internet of Things data, what they call product data, would end up in the hands of the Russians, for example, and so they don't want to deal with that. And so they want to restrict it. And what occurred to me on seeing the Data Act was that although it is very proactive in giving European researchers better access, it seems as though it might be giving African researchers worse access. Okay, because it's worried about, and it might, as far as the EU is concerned, equate Russians with Africans, as it were. And that's not the only one. The Digital Services Act only gives Google data, what they call very large platforms, to vetted European researchers. So you've got to take a look at being vetted. It doesn't say European, but one of the aspects of being vetted is that the research you're doing is good for the European Union. Now, if you're from Africa, it's not entirely obvious to me why the research you're doing would be good for the European Union. And so I'm a little bit concerned that the EU is in the process of creating what I think of as a non-tariff barrier to African researchers, almost unintentionally, so that even though the intentions are good to enable European access, it's not obvious to me that it won't somewhat unintentionally result in a barrier to entry for African researchers, which, you know, is ironic. And it could even be worse. It could be that the prosthetic arm is in Ghana and the data is going to a French company in the European Union who then doesn't share it back to the Ghanaians, which is ironic. So perhaps you can.
Yeah, you're pretty much right. That's the way everything's going. It partly goes down to that the whole intention of the EU and the European Commission is about strengthening the internal market. So their focus has to be on that. How can we improve the internal market within the EU? But it is very much all of the regulation that's going through is all about how we strengthen enable sharing in our context. We will take your data, but here are more barriers in the data going out. So it is a one-way flow, and there's very little data going out at the moment. Even when there's a lot of political will in the context of America, the US has been put a lot of energy into try and remedy this, but it ends up in the Court of Justice of the EU.
I was desperately hoping to be wrong about that.
Dondrik, did you have a comment?
Thank you, Sudha. I think we've now reached 6 o'clock, but if there's the moment for me to respond.
Sure, absolutely.
Thank you. So my colleague, Dr. Staunton, suggested that it might be more productive to move away from terminology of ownership. So I would like to just briefly respond to that. I think if one, this is not going to be a legal response. If one perceives personal data as something that is purely in the domain of privacy law, and that is indeed how many, if not most, European scholars view personal data, then my colleague is completely correct. There's no such a concept even such as ownership in privacy law. In fact, it will just confuse and it will not serve any productive purpose. But now we must remember that European law is, well, let me rather say the following. There are different legal systems. It's perceived differently, for example, in the US, and the reason why I'm now so jet-lagged and can hardly concentrate. So I spent last week in a workshop exactly on this issue in the United States. So the issue of ownership of data is viewed differently because it's a different legal system, different legal tradition. So let me say something from the South African legal perspective. And I can't generalize that that will be the case in the whole of Africa. It might, but in this context, I'm going to limit myself to my safe space, namely South African law. So in South African law, personal data is not confined just to the privacy space. So it's definitely very, very relevant in the space of privacy law. And just to state again, in privacy law, there's no concept such as ownership. But personal data is also relevant in some other spheres of the law, some other branches of the law, such as in the South African context, I would suggest in property law. And then the moment it enters into the property law sphere, then the technical concept of ownership becomes relevant. Not the general meaning of, you know, I've got a moral right or something like that, or it relates to me, but the very technical meaning of ownership in the law, dominion. Then there are two relevant questions. First, data, and this is now quite complex, and that is also why I think many people would rather steer away from it. That's very well understood. But data is a new kind of legal object. It's a digital object. You can replicate it any number of times. It's non-rivalrous. But we must also remember that our law goes back for more than 2,000 years, and even the Romans even had a name in Latin for incorporeal goods. res incorporalis, although this is still quite new because we can replicate it an indefinite number of times. So the question is whether data, well, first one must, data is like the sea, and one clearly cannot own the sea. Or, yeah, well, because humans cannot control the oceans. But here's a bottle of water. You can take a specific measure. What is it? 1 liter, 1.5 liter of water, put it in a bottle, and then you've got a bottle of water. And clearly, I can own this because it's susceptible. You know, humans can control this, and there's value in it. So hence, in our South African law, it is therefore susceptible of private ownership. Now, data generally is like the ocean. It's not susceptible of ownership. All the information, you know, facts that we're supposed to break at 6, things like that are not susceptible of private ownership. But if I package it, in other words, if there's a discrete data instance, namely your genomic sequence, for example, that's saved as a specific file on your computer or on the cloud, that specific data instance is valuable and it is capable of human control. And therefore, I would suggest in South African law, similar to this bottle of water, therefore, a digital good that's susceptible of private ownership. The next question then is who owns it? But I think I've now already taken enough time in my brief response to my colleague Kira. Thank you, Dr. Staunton, for mentioning this. So I think it depends on your legal reality. So in conclusion, if you're in South Africa, you know, then there's a certain legal reality. And I then think one's lexicon, the words that you use must then conform to that legal system. In another legal system, it might be completely different. But I think it's more productive then to be aligned with the legal system in which you find yourself. Thank you for the opportunity.
Right. Do we have time for more questions? Maybe one last quick question before.
Thank you very much. And thanks to the panelists. I have it's not a question, it's an idea in my head. I mean, looking at the data sharing policy or guideline, I know earlier at the data governance session, we had to talk about, but are we looking at what is the take of the data generator? I mean, maybe the patient, the people who have generated this data, what is their take about how they want their data should be shared? I don't know if we are looking at that perspective. I mean, I get to speak with someone who is a lawyer and I mean, is a data governance lawyer. And, you know, he was quite knowledgeable, I mean, challenging me, but I could imagine someone that I met in a hospital and I'm doing a study who had little or nothing about data sharing. I've received consent from, I've obtained consent from him, and maybe it's a dynamic consent I'm looking at or any other form of consent, but I'm not sure whether he is knowledgeable enough to know how he or she wants his data to be shared, whether it's just tabulated data he wants to be shared. I don't know. I mean, it's a question in my head.
I'll take a shot at it because I think I know where you're going with that, but you please correct me. The concept of data sharing relies on consent, but consent needs to be informed, specific, and it's the informed part that we're worried about. So if you go and say, can I please share your data, and they don't get it, then you didn't really get consent, did you? Because they didn't understand you when you asked. That went back to one of the other questions that was put, where if they're illiterate, how do you get consent? And Aliki Edgecombe, I think, was doing some comics where you would be able to see pictures of explaining what you would do, what you wouldn't do. So a different medium in terms of being able to express this. It's been done quite a lot in South Africa. In fact, to some of the farm workers, we used terms and conditions that were purely in the basis of comics. So I think your concept is, or your question is, and I'm hoping I'm right, if the person doesn't appreciate what they're consenting to, are they really consenting? Is that fair? Yes. then the answer to me is no, they're not. And now you've got a proper challenge, because now you're in the situation where you've got to get them to the situation where they do understand. And just how possible is it to get them to understand possibly quite complex concepts relating to how your research is going to work? So is there a level of understanding that is sufficient, rather than understanding it's a dual blind program, whatever that might mean? That may not be sufficient. That is a very tricky area. I think if your participant is illiterate and not very sophisticated, I'm not sure you could ever get true consent for what you were trying to do. And you might have to ask for a lower level of consent, because the higher level of consent is simply not possible. It is a tricky area. I agree with you.
Great, thank you, actually. So I think there are no more questions, but I did want to thank the panel for such a thought-provoking and stimulating presentations, as well as actively participating, and the audience for staying so late. I know we're standing between you and dinner, which I still think you have about 45 minutes to rest up before you party tonight at the banquet. So thank you again. Clearly, there must be so much thought given right from when you think about your science to your research to generating data to what do we do with the data. So many different aspects of data governance, and I thank you all.
Sorry, for members who attended the synthetic data workshop on 5th,